Act 3 presents the government's witnesses. Each one will be examined by a prosecution attorney, followed with a cross-examination by one of the defense attorneys. On rare occasions, the prosecution may redirect questions following the defense's cross. Mr. Chi will conduct the direct and redirect examination of government witness, Deborah Oremland. Ms. Irvin will conduct the cross-examination for the defense. Ms. Oremland is a professional lawyer who works for the Financial Industry Regulatory Authority, commonly known as FINRA. She's been employed there since October 2001 and currently serves as Assistant General Counsel. Ms. Oremland received her undergraduate degree in 1996 from the University of Michigan and her JD Law degree from American University in 2000. She's admitted to practice before the District of Columbia Bar, where she exercises skills in security regulation. Ms. Oremland was 47 years of age at the time of the trial.
FINRA is an independent, non-governmental organization that writes and enforces the rules governing registered brokers and broker-dealer firms in the United States. Its stated mission is to safeguard the investing public against fraud and bad practices. It is considered a self-regulatory organization. FINRA regulates the trading of equities, corporate bonds, securities futures, and options. It is authorized by Congress to protect the interests of investors. FINRA writes and enforces rules that govern registered brokers and broker-dealer firms in the United States. It also administers the qualifying exams for securities professionals. FINRA's monthly report of disciplinary activity refers only to formal actions and leaves out informal ones, such as cautionary letters to firms or individuals. FINRA is the single largest independent regulatory body for securities firms operating in the United States. It oversees more than 3,400 brokerage firms, 152,000 branch offices, and nearly 617,550 registered securities representatives as of 2020. In its enforcement capacity, FINRA has the power to take disciplinary actions against registered individuals or firms that violate its rules. On November 4, 2008, FINRA issued Regulatory Notice 08-66 addressing firms' retail foreign currency exchange activities. It stated, "The retail over-the-counter foreign currency exchange, retail forex market, is opaque, volatile, and risky. Broker-dealers who engage in forex business with their retail customers must comply with the FINRA rules that apply to those activities." Oasis did not engage in retail forex business and was not a FINRA member, so this rule did not apply to Mr. DaCorta. Since Michael DaCorta did not have Oasis dealing in equities, bonds, securities futures, options, or over-the-counter retail forex, which are the regulated operations of concern to FINRA, Ms. Oremland's testimony is only of glancing significance, if any at all, to the case against him. Here again, as in Mr. Howland's earlier testimony, it appears that the prosecution was trying to raise questions about Mr. DaCorta's integrity in the minds of the jurors by merely associating his unrelated former trading activities with FINRA regulation.
Well, you must have been up to something to look that innocent.
Now, what does FINRA do?
FINRA is what's called a self-regulatory organization. It's private, it's non-government, and it's a membership organization, and the members are comprised of broker-dealers and their employees, brokers. And FINRA regulates certain aspects of the securities industry, and its mission is to protect investors and protect the integrity of the market.
Would you please care to explain what a broker-dealer is?
A broker-dealer is an entity. It's a business that's involved with buying and selling stock for itself or for customers.
How does FINRA regulate broker-dealers?
FINRA writes rules to govern broker-dealers' behavior. It conducts compliance examinations to make sure that the businesses and their employees are following the rules. And FINRA can also discipline its members if they're not following the rules.
Does FINRA regulate anybody else or any other entity?
No.
Ms. Oremland explained that FINRA is overseen by the Securities and Exchange Commission, not the CFTC. She stated that she had been an attorney with the Criminal Prosecution Assistance Group, or CPAG, for over 15 years. During her tenure with FINRA, She had done training for the FBI, the IRS, some postal agents, and various U.S. attorneys' offices.
Would you explain to us what types of professionals must be registered with FINRA?
Anyone who wants to buy and sell stock for customers must be registered with FINRA.
Ms. Oremland described the arduous 6-hour examination process of passing the entry-level Series 7 exam needed to register as a general securities representative with FINRA. She said that the passing score is 70 to 72%. She then described the Series 24 exam as a test to make sure that you are equipped to manage and supervise brokers. FINRA keeps a record of all those who have taken their exams in a giant database called the Central Registration Depository, or CRD. The public can search the CRD to find qualified brokers through whom they may wish to trade stocks. Licenses expire after someone stops working at a broker-dealer.
Now, you just mentioned earlier about what happens if someone leaves the industry. So I will ask what happens to the licensing or the licensure of a person who leaves the investing or investment industry.
It expires.
Did you review a CRD report for Michael DaCorta?
Yes.
Now, turning to the section entitled Exam History, could you explain or tell the jury when Mr. DaCorta obtained his Series 7 license?
Sure. He took the Series 7 in January of 1986 for the first time.
Now I see a whole bunch of different exams in the left, first column to the left. Could you explain what an S4 exam is?
Sure. So that's an options principal exam. Taking this test gave him the ability to supervise options trading, individuals that worked with options.
And what does the defendant's CRD report reflect with respect to the Series 24 exam?
He also took the Series 24. He passed it in February of 1988.
And how about the Series 55 exam? What is the Series 55 exam?
That's an equities trading exam. He passed that in March of 1999.
I wonder if we'll be called up as witnesses at the trial. What trial?
Mr. Chi continued to laboriously elicit irrelevant information about the various securities licenses that Mr. DaCorta earned, that he had worked at several broker-dealers over a 10-year period starting in the early 1990s. He completed continuing education requirements in 1999 and again in 2001. Mr. DaCorta filed for bankruptcy in 2001 following a large loss that resulted in the appointment of a trustee and arbitration. The single complaint from an unhappy customer was dismissed in arbitration.
It's impossible to discern why the government felt it necessary, or even useful, for the jury to be burdened with Miss Oremland's irrelevant testimony, or why the poor woman had been required to fly from her home near Washington, D.C. to Tampa, Florida to provide it. None of Mr. DaCorta's former activities in the equity and options markets, which, like his many license exams, took place decades before this trial, had any bearing upon the charges against him, or with the activities he pursued at Oasis.
FINRA regulates broker-dealers that are registered in the United States. Is that correct?
Yes.
And are those broker-dealers that are only involved in stocks and securities? So, for example, it does not include broker-dealers that are involved in Forex trading?
Well, they might have business in foreign exchange, but FINRA regulates broker-dealers that are in the business of buying and selling securities.
And those are broker-dealers that are registered in the United States?
Yes.
When you use the term equity trading, what does that mean?
Oh, that deals with stocks. Like equity is a stock. It's known as a share. It represents an ownership interest in a company.
I rest my case.
It's truly strange that while Miss Irvin asks pertinent questions, she consistently fails to clarify for the jury what point has been implicitly drawn from the testimony she elicited. For example, she just learned that FINRA regulates broker-dealers registered in the United States, but doesn't draw out the point that Oasis's broker-dealer was located outside of the U.S., was not registered in the U.S., and operated under the jurisdiction of English authorities. She fails to clarify that while a U.S. business may have business in foreign exchange, FINRA does not regulate that part of their operations. Further, Ms. Irvin doesn't explain why she asked what equity trading is, or point out that Oasis was never involved with it. Miss Irvin inexplicably asked Miss Oremland a series of completely irrelevant, time-wasting questions such as, what is an AG? What is ET? What is GP, GS, and what is OP? All of these abbreviations refer to positions in the securities industry, and all of them were unrelated either to the charges against Mike or to the operations of Oasis. Of what value to her client was reiterating that Mr. DaCorta had filed for bankruptcy in 2001, or getting the witness to confirm that he attended St. Lucy's parochial school through 8th grade, high school at Blessed Sacrament in New Rochelle, that he worked at Ann and Tony's restaurant in 1984 and 1986, and Gino's Cafe in 1985 and 1986. So what?
Why do we keep doing this?
Ms. Irvin wasted valuable time and no doubt bored the jurors out of their seats by going over FINRA's record of Mr. DaCorta's irrelevant employment in the securities industry, company by company, from 1985 to 1999, when the report she was referring stopped and information was transitioned to another report which, thank the attending angels, was not a government exhibit that Ms. Irvin wished to belabor her witness and the jury with further.
Unfortunately for all present on this forgettable occasion, Mr. Chi felt it incumbent to enact a redirect examination of the witness in order to recall Mr. DaCorta's legacy employment history and thereby awaken those who had fallen comatose in the jury box with yet another rousing review of Mike's Series 7 exam history, the point in the chronological history of his many employments at which he left the insurance industry, when it was that he worked at Jem's Beverage World, and the precise moment, had it only been available from the exhibit, that he left the securities industry in 2002, perhaps 20 years before the trial, and some 9 before Oasis was summoned into existence by the defendant's well-tutored machinations.
You gave him a 1?
He's never been better.